This is the workshop for March 31st, the ZBA workshop for March 31st, 2026. And this is something we try to do every year, but I don't think we have, just to try and sit down and discuss some topics of interest, updates to zoning ordinances, hear from the planning staff and our legal staff. And so with that, we're going to start with some agenda items that we have put together for discussion for planning staff.
Could I make a brief preliminary statement? It involves you.
Sure.
Actually. So when I got appointed to this board, before I actually had sat on any meetings, I met Beth downtown, coffee shop one day, and she says, "Well, welcome to the zoning board," she said, "but you have to remember this," she says, "you were just another zoning board member. You were no longer the city attorney, which you were for those 40 years. And so you have to stay within your guidelines and play the proper role." I felt that Beth was right about that. And I have made a huge effort to be respectful of that concept. And I will, and you'll see at meetings, I do not try to act like I know more than anybody else, or do anything other than what a normal board member would do. And it's going to be that same way tonight.
As he looks at Trevor.
which is why I'm saying this, because Trevor's the guy, not me, and I will probably not say anything at all.
Thanks, Bob. I think if I may,
Sure, of course.
kind of respond to that a little bit. Obviously, I learned a ton of stuff from you, and you have all the experience, and you that's just not limited to you. I mean, you board members, you can read the law, and you have read the law, and you apply this all the time, and in a way that I was used to when I worked for you, Bob. I think what I can do here is, provide you guys with, I can go and read the law and read cases and do a lot of research and try and think it through and provide you guys with stuff that I think might be helpful as you try to do your job that is before you. It's not my job, this is your job. And I'm just going to try to provide you with kind of helpful bits of law, helpful bits of knowledge that I've been able to find and put together that I hope is useful to you all as you do what is, you tackle the jobs in front of you. And I think that's kind of my approach here. And, if you have questions, if there's things that I can answer, I may know it, I may not, I may have to go look up the answer, but I'll try my best to be as helpful and be a resource to you all as I really can. And I hope that is useful.
All right, well, thank you, Trevor. I mean, obviously, the more information we have, the better. And obviously, although Bob is no longer the city attorney, he brings a lot of experience and perspective as the city attorney, which only enriches the board's deliberations, I think.
It's amazing how often the cases that people are presenting to you in support of their argument were actually my cases that I had in the Supreme Court.
All right, so with that aside, why don't we start with, we're going to go through zoning updates, which we hope will be pretty quick and is helpful for us to know. And there's a new little zoning ordinance. So, yes.
If you ask for one.
Yeah, apparently only if you ask for it.
If you ask for one, but we can always make more. It's just a lot of paper, so we didn't want to make too many.
All right, so why don't you guys take it away then?
All right, so zoning updates I'm actually going to pass to Peter Stith.
So good evening. I was asked to come and give a rundown of kind of the past. I'm going to go from 2024, what's been adopted since then. And all of these amendments for the ordinance and the map are all in an appendix in the back of the ordinance. So whoever got a paper copy, those are up to date. So going back to May of 2024, there were amendments related to electric vehicle charging stations. There was a push to add more to the ordinance to allow EV charging. And there were two definitions, EV fueling space A and B. And EV fueling space A is relative to your typical residential electric service, so you don't have to upgrade to, so you could have it at your house. And so those are accessory to residential uses. The EV fueling space B is more of something you'd see in a commercial, like at a gas station, or that has large infrastructure to support it. So those amendments were made in 2024. The next amendment was in June of 2024 related to home occupation. And this was a big push from the artists community who wanted to teach art or classes at their home. I think if you probably remember.
Yeah, it came out of one of our decisions,
from
yeah.
one of your decisions, so.
Yeah.
And the definition of home occupation did not provide for people to have that. You couldn't have any visitation from clientele or the general public. So the amendments related to home occupation 1 allowed for up to 2 clients or visitors at any one time. And then that's permitted by right. And then home occupation 2, which is allowed by conditional use permit now, it allows up to 6 clients at any one time.
Excuse me, while you're going through significant changes, would you mind calling out the section of the zoning ordinance so that we could rapidly flip to it?
It's in the appendix.
So this is the definitions in the appendix?
Right, so the definitions are in Article 15. The use tables are in Article 10.440, the table of uses. And specifically for occupations, that's use 19.22.
Okay. Thank you.
Then in July of 2024, there were some amendments made to solar, specifically in the historic district. You probably were aware of this. This was kind of a hot topic item.
Never heard of it, just kidding.
And so there were certain exemptions allowed if the panels were not visible, and so you could have these pertain to roof-mounted solar. Then that November, we adopted a Gateway Neighborhood Overlay District for Commerce Way and Portsmouth Boulevard, which is predominantly zoned office research, and it allowed for an overlay to create housing modeled after the Gateway zoning, with some slight changes to make it and it included 3 options for workforce housing. If there are incentives similar to that's what's found in the Gateway, and there are 3 options for providing workforce housing. You could build it, payment in lieu of providing it, or then donation of land to build. And so we have one project that is coming to planning board in April, and that proposal has 3 6-story buildings that are 270 units, and they're going to give the city, I think, 1.5 acres of land to build workforce housing. And then in March of 2015, this is something that's more relative to this board. There were amendments made to the mechanical units. That section was removed. Also, the changes to fence height, so you can have a 8-foot fence on the side and rear yard, and also allowed for 1 and 2 family dwellings to have a 120 up to a 120 square foot shed or playhouse or structure that's exempt from zoning. So it could be in the setbacks. It doesn't have to count towards building coverage, and then it also exempted things like hot tubs and saunas.
And tree houses.
And tree houses, yep. In May of 2025, the city adopted co-living as a use and a section on co-living. And we've had 1 application that has been approved for co-living through the planning board. That's downtown. And then that brings us to February of this year. When the mechanical units when that section was removed, there was still some confusion about whether they have to meet setbacks or whether they're structures. So we just clarified that mechanical systems were exempt from yards and building coverage. And then in consultation with the fire department, building inspection department, they do have requirements for power generators that they have to be set back 5 feet from openings and lot lines. So we added a provision, a definition for power generators and a requirement that they have to be set back 5 feet. So the HVAC units are exempt, but if you have a power generator, that has to have a setback. So that's consistent with the fire code. And then other amendments that were made this year related to, there's some for solar, for ground-mounted solar. So we're allowed to have roof-mounted solar, but we didn't have anything in the ordinance for ground-mounted solar. So we created a definition for ground-mounted solar, and then distinguish between when it's an accessory use or a principal use, and where that's allowed in the city. And it's all, as a principal use, it's by conditional use permit. And then the next few amendments were to comply with state law. There were changes made that were adopted, that went into effect in July, related to accessory dwelling units, which really drastically changed our ordinance on ADUs. And now they're basically by right. We have to treat them like a single-family dwelling. We can't have additional requirements above what we have for a single-family dwelling. So we had previously in the ordinance a lot of things with architectural, height, setbacks. That all went away. The state law said you can't require less than 750 square feet. And so we have set our minimum and maximum at 750 square feet. The state law allows you to go above the 750, but most of the ADUs we see are well under 750 square feet. And the planning board felt, let's just leave it at 750 and see how many more we get. But we've had probably 12 to 15 since July that have come in and just gotten a building permit for ADU.
But they still have to be owned, the owner.
Right, the owner
yeah,
occupancy,
yeah.
you still have to, have one parking space. One of the things, you can put it in a non-conforming structure without a variance. So if you don't, obviously you're not expanding it, but if you have a shed that's in the setback or a garage, you can convert that interior to an ADU without the need for a variance if it's non-conforming.
If you're not expanding that
But
structure.
right, if you expand it or it has to be a variance.
And ADUs being in front of the principal building, did that get affected? Because the requirement was the ADU could not be in
Right.
front of a primary
So I think
structure.
that we would still treat it as an accessory structure and apply it to being located in front of the house. Yeah. So it's still an accessory structure. So you couldn't put it in your front yard in front of the house. But right, there was an offset that it had to be set back a certain distance from the.
Yeah, or at least behind the
facade of the house.
facade of the primary structure.
So now it could be even.
Right, now it could be even.
That's fine, yeah.
There were parking amendments or a parking statute that said you can't require more than one parking space per dwelling unit. So our regulations had half a space for 500 square feet and less. And then for 500 to 750, we had one space, and then over 750, we had 1.3. So we changed that to just, if it's up to 500, it's half a space, and then anything over 500, it's one space.
That's for all units or just ADUs?
That's for all residential dwelling units. And then we had a request from the Albacore to change their zone to single residence B. And you remember they came a couple years ago to get a variance for the visitor center. They had requested to be rezoned to gateway and to allow museum as a permitted use in the gateway. So that was adopted. So the planning board recommended changing it to Gateway 2 because you have Gateway 2 along Chase Drive and Market Street, which is close to this. And then they changed museum from special exception to permitted in Gateway 1 and Gateway 2. We've had some map amendments. The planning board's been working on, through the housing committee and the land use committee, rezoning properties that have been commercial to gateway. So that happened in 2024. And there's another 10 parcels that are up for third reading on Monday night. Mainly along Lafayette Road and That's the bulk of them. I think there are about 10 properties. So that's to date what's been going on. I know the planning board is working on removing the parking regulations from the zoning ordinance and putting them into site plan regulations, so that someone could ask for a waiver to have less parking than is required. Right now, you have to get a conditional use permit if you have less than or more than the maximum allowed. They're working on that, and then some other definitional changes. You remember 58 Humphreys, so we're working on some definitional changes related to front lot line and lot area and such, so that it's clear what we want, our intent is of how you measure lot area and what's included in that, and so that should be coming in the next couple months. So
Is that all, Peter?
that's all. Yeah.
One additional question, if I may. The state law that says you have to allow residential in all commercial and industrial.
That was going to be my next. So that we haven't addressed. I know that goes into effect in July, so that's something that we need to address. I know there's a law now that is amending it. I think there was a proposal to repeal that, I think by Newington, but there have been some changes to that law, so we'll see what happens, and then we have to act and amend the ordinance. But, there's only a little area, office research, general business, and maybe one other district that doesn't allow residential. That's commercial. We would have to allow.
Okay, Tom?
So you mentioned removing the parking regulations, I think. So I guess my question is, are you going to update the special exception conditions section to remove the fact that in theory the ZBA can impose off-street parking and loading spaces in excess of the minimum requirements of the ordinance? That's section 10.232.38. It seems inconsistent to allow us to do that if you're moving the parking regulations somewhere else.
I don't know. We'll have to discuss that, because if this right, this is additional to the criteria. This is approvals may be subject to appropriate conditions, including but not limited to. And then it mentions off-street parking. We'll probably flag that, for the discussion at the planning board. But that's a good point.
Anyone else have any questions? Paul?
What's the status on murals?
Well, now they're considered a sign.
I understand
I
that.
know. So we haven't
You haven't addressed it?
addressed it yet, but
Okay, okay.
if this board has things,
It's come up in
It's
front
come
of this
up a lot,
board
I know,
quite a
right.
few times, and we're left with a sign ordinance that doesn't apply.
right. So it would be appropriate, I think, if this board send a recommendation to the planning board. Hey, can you look at this?
I do think that's something we should do,
Yeah.
because I have been reluctant, or I've never really granted them, because if something's not in the zoning ordinance, you're not supposed to grant a variance for it. And murals, we've had 3 or 4, I think.
Yeah.
Yeah. So.
No, I mean, I get it. This board can send in a recommendation, but we're not the arts board nor the arts city. If murals start getting denied because there's no zoning for it, then
Well,
that's,
and then I'm sorry. Then there's the court case too that kind of gummed that whole thing up, right? About freedom of
Conway.
expression, and I don't know, Trevor, you have any insight on that?
But that particular court case, the problem was the way they wrote the zoning ordinance to say it had to be, I think, a commercial sign or something. If they would have written it in a different way, they probably would have gotten away with banning it if they just.
Well, there was also a distinction too between how it was written
Right.
and
how
how
they
it was
enforced it.
enforced.
Right.
So that was the real issue there, was that they weren't actually following their ordinance. Makes it hard to uphold your decision and if you're not actually following what's written.
Paul?
Okay, besides murals, is anybody looking at rezoning Ocean Road?
Not that I'm aware of. I mean, we haven't been.
Okay. Since, by my rough count, I would say 80 to 90% of the properties are zoned incorrectly. I mean, once you get past the neighborhoods, the sisters, which are all SRB, which, except for maybe 3 lots, none of them are 15,000 feet. None of them have 100-foot frontage. Once you get beyond that, everything else up Ocean Road is zoned the same as the Woodlands, meaning every lot, every house lot must have an acre.
I will say that the master planning process, our consultant, they're looking at exactly this, like our residential districts and how much is non-conforming and conforming.
The reason I bring this up is we've already had at least 2, possibly 3 cases where people are applying for a variance and their zoning is basically telling their entire house is non-conforming because of the building coverage for SRA. You don't take the, whatever it is, the 15% and apply it to an acre. You take the 15% and apply it to the lot, which makes 1,000 square foot home non-conforming. So, I mean, that seems to me like a very simple change, going through every lot, I've already done it, to say whether or not this is complies and see how many actually comply. Because I've been in this town long enough to realize that when zoning is applied, it's blanket.
Right.
It's not individual. And I get the nuances of you can't just pick out each house, so on and so forth. I get that. But at the same time, when these things are obviously zoned incorrectly to the homeowner's disadvantage, that needs to be addressed. Now, I'm not suggesting you change somebody's zoning who has an acre of land on that property and fits the SRA zoning to get changed. I think everybody else should be, because it serves them, it's a dinner. They walk into the city hall with a built-in hardship, period. And the hardship is because of the zoning, because it's incorrect.
Right, so I think you'll see coming out of the master plan process, some recommendations on just exactly what you're saying.
Yeah. Not a lot of people participate in the master plan process.
Well, that's a good opportunity to plug the meeting. It's coming up on April 22nd. So get the word out, whoever's listening.
It's not my home.
Oh, I know, but, you know.
Okay.
Tom, you got another one?
No, it's been covered.
You tell me the other Tom.
Tom, not Tom.
Tom, yeah, Tom, not Tom.
Next time, please specify Tom.
Yeah, I mean, Paul's question, I'm a little confused or don't quite understand how the zoning board provides feedback to the planning board. You know, we've had some discussions at times during our meetings, for example, kind of questioning what the zoning ordinance says. But we haven't actually formulated that, because I don't know if the opinions are held by everybody on the board or not, but we haven't actually formulated any of that to get to the planning board for potential changes. To give you a couple examples, you know, we were talking about yards, you know, how yards are defined, front, rear, side, all that stuff, not just how they're measured, but how they're defined. And then there are others, like we sometimes kind of roll our eyes when someone has to come in to get a variance because their lot coverage is increasing by 0.1%, which we've had. we had a guy come in who wanted to redo his porch, and it increased his lot coverage, and it goes up by 0.1%. Some of those requirements seem just to be unnecessarily onerous, and seems, I don't know how we get that feedback to the planning board. We don't seem to have a mechanism set up to do that on a routine basis. There are probably others that other members have. Those are just two things that, I can remember coming up.
Do you wanna take that, Trevor?
Sure. I mean, it's something that we've talked about as staff for sure, and I think the most effective. I mean, anybody can write a letter to anybody, as a preliminary. But I think the most effective way is, if and I know that you all have a lot of demands on your time, and you're all volunteers, and I certainly appreciate that. But if we could meet in a setting like this and talk through some of those things, and then staff could help the chair to write a letter, kind of memorializing those thoughts, a letter from the chair to the chair, from Chair Marchson to Chair Chelman, kind of memorializing those thoughts in an organized way to say, hey, here's some things that we're seeing. Here's some things that we really think would help people, would help people, understand this ordinance, would help, help it match better in our community. I think that'd be really valuable. As I'm sure not all of you watch every planning board meeting, I'm sure every planning board member doesn't watch every Board of Adjustment meeting, so they're not seeing what you see. So the only way to communicate that to them is to tell them.
Dave?
Yeah, so one other thing we did, I think like a decade or so ago, we had a joint work session
Oh yeah.
between Planning Board and the Zoning Board of Adjustment, where we kind of went through like a lot of the things that we were seeing, and it was very eye-opening, I think, for the Planning Board members to actually hear like some of the things that we were struggling with. So that's another opportunity to really directly communicate with the Planning Board members and staff as well.
Was there an agenda for that, Dave? Or was it a free-for-all?
It was a long time ago. It definitely wasn't a free-for-all. I mean, I think we had suggested some topics that we thought were things that we wanted to bring attention to the Planning Board, and kind of went through those, and then maybe there was some like free-form discussion at the end.
2015, 2016?
Yeah, it was like a decade-ish ago.
I mean,
City Hall Chambers, right?
If you're seeing consistent things coming to the zoning, I mean, that's a good flag to say, hey, maybe we need to change the ordinance. Like the mechanical units, I mean, you were seeing those constantly, right? And so that means maybe we have a ordinance that needs to be changed.
And certainly staff knows, I mean, I'm sure Stephanie and Julian, you guys pass along stuff as you're seeing it to you, but that's still a great way to have like some interactive discussion.
Look into that. So,
But again, it's another night meeting that we certainly have plenty of already.
all right, so anything else, Peter, or anything else?
I'd like to make a further comment on Tom's comment about the, I call them de minimis changes that come before us, 25.1% coverage, 25%, that sort of thing. I'm not sure that's a zoning ordinance issue as much as it is a sort of a planning department process issue. I don't know about the legalities of how you manage this, but I do think that it might be reasonable to say that for certain of our dimensional requirements and lot coverage and things of that nature, that a variance within a certain tight percentage would not require being elevated to the Zoning Board of Adjustment for review and approval. I wouldn't change the ordinance, because if you do that and say you can get up to, it's 25% lot coverage plus or minus 2%, then the new limit is 27%. We'll be seeing a bunch of stuff at 27.1. But if it's a internal process, I think it could work.
So my thinking on that was somewhat similar, that if there was some way to give discretion to the permitting officer for de minimis changes, then that might cover that they could grant the permit. And yes, you'd have to figure out some way to define the limits, but you would give him or her some discretion on approving permit requests and not requiring it to go to the ZBA. You know, you don't want
Know
somebody
if
to
we
have,
can do that though.
I mean, you know, it's,
That's what the zoning ordinance says.
well, that's what I mean, you'd write that into the zoning.
Yeah, and just on that, I mean, if the other possibility is to, like, because I think the HTC has like a short form process, right? Where there's some things that come before them that are just like, hey, we get through 90% of it and then we just do a quick vote at a meeting. So it still does go through the board itself, but as opposed to the full presentation, vote, go through the criteria process, it may be
Administrative.
The administrative
for an
approvals,
administrative
yeah,
type
yeah.
approval. And then that way, if a member did have a particular concern with it or
We can take it out.
then we can say, hey, we don't think administrative is adequate for this process. We think it needs to go through the full process.
And I might
about that.
Yeah, because I mean, I think that's something that legally we have to think whether or not we are able to do that for the ZBA.
also,
Or
you
if
know,
it's a
again,
planning board process.
staying within the bounds of legality, I'll, just hit you with this from my perspective as a chemist who has had to confront the issue of significant figures and calculations many, many times. It is absurd to assume that, our ordinance, does it say 25.0% lot coverage? If it did, then anything after that decimal place would be considered a significant figure. It says 25%. So unless that last digit changes, it is not a change relative to the ordinance. So I do think that we are perfectly within legal boundaries to round down if something is 0.4% deviation from whatever the requirement is. It's not always going to be in percentages, but if the decimal can be rounded down, that is not a change in the significant figures as per the ordinance. So I think that is simply just a matter of how you interpret a calculator. I don't think it's.
We have calculations for parking, and it says in the ordinance, if it's a percentage, you round up, so.
That's parking, that's not.
I know, I'm saying we could have similar language that says if building coverage calculation is less than 0.5, it's rounded down.
In fact,
We'll have to look at that.
I don't think you actually even need that language because it's standard practice in, in significant figures to round to a significant figure, and our ordinance does not include excessive significant figures, except for in the ordinance numbering scheme.
I will say that when applicants come in and it's like 25.6%, we do round up,
That's
to give
correct.
them some buffer if it does indeed go over
25.6, I would round up too, but 25.4.
I mean, when
would
we're
round up.
noticing it.
Yeah.
So that if they, it comes in and it's not 25.6, when they get to the building permit stage, it's actually 26%, then they're good.
Yep, I would do the same thing. A 0.6 should be rounded up. Anything less than a 0.5 should be rounded down. It would just alleviate probably half of the super trivial applications.
I don't think this is something we're gonna solve
No,
tonight.
we're not, so.
We
I
don't
think
have to.
this, we've,
Good input.
yeah, so this is input
For a long time.
and we'll let planning staff sort of toss that around for a little bit. So anything else on zoning updates?
No,
I'd like to move on.
Yeah, please, move on.
Okay, all right. So, the next thing we had talked about, I think board member etiquette, I'm trying to think of the,
Yeah, so I can run through application process real quick.
let's do that.
So Beth asked me to just touch on the application process, and I've been able to boil it down to 4 bullet points, but I don't want to minimize the efforts as some of these applicants go through. It can take years to get through some of this stuff. So usually when we see applicants, it starts with a pre-application meeting. They give a call to either myself or Jillian or Peter, and they want us to come in, sit down and discuss their project, whether, they have a full, baked idea of this is what we want to do, how do we get in front of the board, or this is what we're thinking, what are some of the hurdles that we have to contemplate. From there, once they have their full plans, they go through the application process, they submit their online application, it goes through a preliminary review. Sometimes, we flag it, you're not ready yet, you don't have all of your application materials, or, you know, if they haven't had a pre-application meeting and we think it'll be beneficial for them to do that before going to the board, we suggest that. Sometimes we also kick them to a TAC work session or a conservation commission work session if that's appropriate. From there, you know, once they have their full application, we do a full review, send out the legal notice, the memo and the packets go out to you guys, and you meet, you make your decision, and after that, the letters of decision go out, and that's the official, have your approval from the Board of Adjustment. After that, the applicants, if appropriate, need to go to other boards, Conservation Commission, Planning Board, and then they can get their building permit. I wanted to note that in the building permit process, we have an interdepartmental consistency review step, which is, I don't know if you are familiar with Vincent Hayes. He's meticulous when that gets to his step, and he cross-references all the approvals that the applicant has gone through and gotten, and makes sure that everything lines up and is the same as what they are applying for in their building permit. You would be very surprised to know how many applicants changed their projects between BOA and the building permit. So there's a lot that filters out a lot of projects, and it's not always the applicant's fault. You know, they don't understand the rules all the time. That's why we're here, to tell them, you know, this is what you got your approval for. This is what you can do. Any questions on that?
Yeah, I was just wondering roughly what proportion of your guys' time is dedicated to handling essentially zoning board prep, application process and packets and whatnot, versus other planning department tasks.
Make sure that we're taking up a majority of your time.
It's definitely the majority of my time.
Yeah.
I think Jillian can also say that with the double meeting
A
months.
little less than Steph, but okay.
Yeah, and every question I have, I always bring to Peter Stiff, so probably a decent amount of his time too.
I got a question related to your consistency review, because that leads to a question that I had. In all of the meeting packages, you've got that boilerplate language on all the applications for variances. References section 10.235, certain representations deemed conditions. And we have talked at meetings about how when we grant our variances, it's based on what we see in front of us. And I've noticed that there have been at least a few instances where what goes to a different board is different than what the ZBA saw when we granted our variances. And so I'm curious as to how that section should be interpreted and applied. Does it just mean you can change anything as long as it doesn't conflict with one of the variances you got? Or does it really relate to the design of the particular project and structure? Because I've seen, I don't want to get any specific examples, but I've seen some things go to the planning board that are not what we saw when we granted our variances. And in some cases, it might be because we didn't grant all of the variances requested. In other cases, the changes may not be directly related to the variance they requested, so maybe that's why they slide through. But I just don't really understand what 10.235 means. That's what it boils down to.
Yeah, I can take a stab at it. So every project is different. Every situation is different, so I'm going to use the word usually. Usually when we're looking at a change, I'm assessing, you know, what were the variances granted? Is it going to change the relief that was needed? I'm also going to look at, is it more non-conforming than what you saw? And I'm also going to look at, are any of these changes going to change, could they have possibly changed the conversation that was had by the board? And that's how I look at it. Again, everything's different. When we do see changes, a lot of time we go back into the minutes, into the tape, we listen to the discussion again. Did this come up? Was it, you know, contemplated in this way or that way? You know, did you guys directly talk about this? And is this change something that would directly go against the conversation that was had? That's kind of how I look at it.
And I guess as in a way of an example, something that we saw just recently was like a shed or a garage that had been granted relief to be within the setbacks. And what was presented to the board did not have dormers on it, but what was put into the building permit did. So that dormer would indeed have affected the conversation because it's more non-conforming, an extension of the non-conformity within the setback. So we were like, you can't do the dormers because that's not what was presented to the board. If that helps as an example.
Just like to make a general comment. I guess I'm halfway through my 5th year on the board now, and I've noticed a very welcome increase in the quality and the organization and the ease of use of the materials that the planning staff prepares for the board meetings. I think you guys are doing a great job, and you probably don't get told that very often, certainly not by me, because I'm not that kind of person, but I really do think that things are going really well from the standpoint of what you put together for us. Every once in a while, there's a little bit of a hiccup, but by and large, you guys are on it, and usually when we have questions, you're able to answer them live, and I certainly appreciate it. I think you guys are doing a great job.
Tom?
How is the planning department's interactions with the Public Works? Because Public Works still does have authority to grant certain things like driveway cuts and whatnot that have caused issues in the past where somebody gets a driveway cut but actually wouldn't have had the open lot coverage to be able to support having a driveway. So I know that there's been efforts towards that, and how would you characterize that conversation?
I haven't seen any issues, to be honest.
I think when the second driveway comes in, you run it by Eric usually, right?
Yeah.
So is Public Works communicating when they've received those types of requests?
I think you run it, like if someone comes in for a second driveway, you should run it by, just say, hey, does this look like an appropriate location? You know, do you have any issues with that?
Bill always flag a second driveway to us.
Once upon a time, they were very bad at it.
I think the online system helps because,
Okay.
Yeah.
you know, the whole system is connected. They can tag us, we can tag them pretty easily, and it just pops up and you can, it's pretty instantaneous.
Okay.
I want to reiterate what Tom says. You guys do a great job. And you're not told that enough. Just a piece of advice to the applicants. Not so much the residential applicants, but more the people who are already planning to go through multiple boards. Because our charge is to approve applications as presented, there are plenty of times when there's information that's in that application that either contradicts what they're asking for or contradicts what the applicant is telling the board. For me, that's an instant denial. I will ask the question to get it explained, and usually it's, well, that you don't need to look at that material. Well, that material's in your application. Or they haven't reviewed the application for contradictions. My advice to the planning staff is to admonish those thick applications before they come to the BOA to take out anything that we're not going to be voting on, or any additional information that they may see to add to their case, and only adds more questions on our side.
So these are like applications that basically they give us the planning board application as part of their ZBA application. I think we've we've seen a few of those, so.
Yeah, but I mean, it comes, I have heard too many applicants' representatives tell us what our job is, or totally describe a comparison property totally wrong, totally incorrect. And I'm like, I don't know whether they are too busy, it's a lack of preparation, or whatever. But when a professional gets up, as opposed to a homeowner, the criteria are going to be stricter. Criteria are the same, but this person's being paid to do his job. And I mean, if they misspeak, or I'm going to dive into it, but they shouldn't have things in the application that are irrelevant to the application. Simpler is better.
Anything else on that? All right, so I think this sort of, the process, one thing that I've become aware of since I've become chair is the process after our meetings. When we leave, we're done, but there's still a lot of heavy lifting that the planning staff has to do, and that's getting the letters of decisions and out to the applicants. So I think that leads and that's a heavy lift for Steph and Jillian to actually write up what our findings are, how we go through the criteria and whatnot. So I think, why don't we segue that to how to, making a motion. And I think that I would like to see a little bit more simplicity when we're actually making the motion. I don't think we need to, discuss or say what we think about the project one way or the other, kind of go through all those gyrations. I think I would like to see more that the going through the criteria simply and being clear about how our findings match the criteria that we're talking about. We usually take spirit and intent together and whatnot, and making sure that the second seconds the first motion. So that, it's really more of a problem in a denial. If somebody denies on spirit and intent and then the second is more talking about hardship, I think that we really need to be very cognizant that, I think Bob had told us this once when he was city attorney, that, we may all agree on the result of a vote, but we may have gotten there in a different way, One person found a problem with spirit and intent, one person found a problem with substantial justice. So I don't know if there's anything the planning staff wants to add to that, but making sure the second lines up with the first, and that we try and keep our motions concise and clear and speaking to what criterion we're talking about. Because it's better legally, it's also, I think, better for the staff who have a huge amount of work to do after the meetings. We have to get the letters of decision out within 5 days. That's the law. I don't know if there's anything the folks who actually write these things for us want to add.
I'll just add that, when we're writing up the findings of fact, we take it right out of the minutes. So just clarity on when you're going through your motion and the findings of fact, just be real clear about what it is that you're finding on each of the criteria. Because we'll take it right out of the minutes.
Tom?
I guess I want to make sure I understand what you're looking for. I'm trying to remember our motions, and I know most of the motions for approval, we don't list the criteria right in the motion generally. We say, motion generally reads to approve the variances requested and advertised. And then, assuming we get a second, then we go through and list the criteria. That's okay.
That's okay.
Yes.
Okay, so then the question is the same approach okay or not for a denial? Are you suggesting that the denial should say, we denied the variances on the basis of, and then list which criteria we think it doesn't meet, not necessarily in detail. And then if we get a second, go through and explain how that works. So in other words, this motion is denied because deny the variances because they don't comply with the spirit of the ordinance. Get a second, then you say it doesn't comply with the spirit of the ordinance because. Because right now, I think what we're just doing is saying deny the variances as requested. And then when we get the second, we go through, and that's when we start piling on with reasons, and the maker of the motion may have one reason, seconder may have another, somebody else in the audience may, somebody else at the table may have a third. Is that what you're looking for? You'd rather the motion list which criteria failed in the motion, and then we can elaborate on it afterwards?
Specifically for motions to deny, yes.
So then if the seconder wanted to add another thing that failed, technically that should be a motion to amend?
Yeah.
Or get the, somehow convince the maker to add that in, one or the other?
It would make it much clearer for us when we're writing it up that that was part of the original motion or the ultimate motion that was made.
If I could add in
Of course.
a little bit here too, be just as somebody who is defending your decisions right now in court and having to file answers and things of that nature, some things that will be helpful to me, you know, especially when you're denying, you know, list all the reasons why it fails, right? Not just, well, you know, we reached the first one and it failed the first one and we're not going to reach the rest. I mean, you can do it that way. But if you think that it failed, say, all the criteria, then go through them all. Because you only have to be right on one. You know, your decision only has to be upheld on one. And if you can list the rationale behind each one of them, you know, as you're making, you know, once you've made the motion, and the second can chime in as well, and then you can amend the motion, adding in the opinions of others. You know, if you give that kind of factual backup for your decision, that gives me a lot to hang my hat on. And, you know, and from there, I can still always do what, you know, what lawyers have been doing when arguing over ZBA decisions forever, which is cherry pick nice quotes from the discussion. You know, I'll obviously continue to do that. But what the judge is really looking for is you know, once you've made that motion, each of the criteria and that support that you've laid out. And the second can go through their own, and then again, you amend the motion by incorporating the rationale from other members as well. And the clearer you can make it and the more organized you can be as you go through it, you know, the easier it is for me to try and you know, argue in defense of your decisions.
Yeah, and I certainly agree with that. I mean, if we, as much as we can put into, especially a denial, because again, sometimes we just say, hey, I only need to fail on one. But if we can show multiple, as you point out, that can help if it gets appealed. But even in an approval, some of them are pretty controversial, and some of them do get appealed that we shouldn't have granted that approval. And so, you know, being deliberate, especially where we sense that maybe a particular case might have some controversy associated with it, being really crystal clear about how we see it meeting the criteria, I would think could be beneficial for you as well.
Yeah, absolutely. And I didn't mean to just harp on the denials, but certainly with the approvals as well, especially as you say, if it's controversial, but sometimes you don't know when it's going to be appealed. Very helpful to go through those in a lot of detail and again, give me a lot to hang my hat on, because a lot of, if you're thorough, you know, it's easy to get it upheld, your decisions upheld, because you're the fact finder.
Easier, hopefully.
Easier, yeah, sure.
We've still had things overturned over the years, but
Certainly.
so and I guess I'm still kind of a little concerned about, so if I second something and I feel that the maker of the motion, when they went through the criteria, didn't capture everything, if I see something additional, how do you want that captured? Because to me, if we say, hey, in addition to what the maker of the motion said, here's some other considerations, then we ultimately vote on that motion that was made and how it was seconded, right? So if everybody agrees with what was said there, then we vote on it and we say, yes, we're good with it. I guess I'm just curious procedurally how you see that happening.
You want to try that?
Sure, yeah. So procedurally, how I would see it happening is, you know, there's the maker of the makes the motion, second seconds. The first goes through their rationale for why, right? The chair then says, does the second have anything to add?
Right.
Then the second goes through and adds in their rationale as well.
Right.
And you know, hopefully they agree. Yeah.
Yeah, I mean, should fundamentally agree, although normally if I'm seconding and I'm adding something, it's because I saw that
Yep.
You know, there may be something I either see or maybe want to, you know, further clarify that the maker of the motion made.
Yep.
But now, Stephanie, you're kind of telling us that you have a hard time then collapsing that additional commentary into the information we provide back to the applicant?
For me, when I'm doing up those findings of fact, it is tough sometimes to tell, okay, you know, Tom had his comments, Dave had his comments. Am I supposed to take all these comments, or am I supposed to take just Tom's comments because Dave made those comments, but it wasn't agreed by Tom to include them as official reasoning?
Which
So, for me,
this time, just ignore David's stuff.
so I see where you're coming from, where it makes sense, but if we could just make that crystal clear, if Tom wants to go, yeah, I'd like to include that as as a wholesome findings of fact.
Yeah, I think that's easier for approval, because on approval, they have to meet all the requirements. So there's not any question about, I mean, Dave's just piling on, right? I mean, I may say it meets this requirement here. The difference, I think, is on denial. I think we need to be clear about what the reasons are for denial, because it often doesn't just stop with the maker and the seconder. Often somebody else adds on and says, well, I think in addition to not meeting the spirit of the ordinance, I don't think it meets the hardship criteria. That's not coming from the maker or the seconder unless we somehow write that into the,
Or agree to amend the motion.
Well,
that's when we think it
That's
should
where we
amend the
amend.
motion.
that's where you amend the
That's where we
motion,
amend.
because you're, sorry.
And the first and the second would need to be amenable to the amendment. Yeah. So,
You're not really amending the motion, though. You're simply adding some more facts associated with the motion. That's where I guess I'm having a disconnect with
It's more
what you're
criteria
saying.
that should be amended,
I think
Well, the motion doesn't say, here's my motion and here's, then we talk separately to the criteria that we think supports our motion.
I think what they're suggesting is that for a denial, we say in the motion what the criteria is that fails. I move to deny because it doesn't comply with the spirit of the ordinance. You second it. Then we go through and explain why it doesn't comply with the spirit of the ordinance. If somebody else wants to say, in addition to not complying with the spirit of the ordinance,
Okay.
Hardship.
it's a hardship,
Yeah.
then we should add that in. Typically, under Roberts, a motion to amend doesn't require approval of the maker and the seconder if everybody votes for it, or if it has a majority that votes for that amendment. But the formal process would be a motion to amend to add this in, we vote on, gets a second, we vote on that, and then that becomes the main motion, assuming it passes. Spent 2 years.
I was impressed.
Wait, I just want to sort of, before we go to other comments. So what you're saying is that there's no need to amend if everybody votes on the motion, even with that sort of additional, the non-first and second.
You're saying just the opposite.
What I'm saying is on a motion to deny, if we want to add additional criteria to the reason for denial, we should make a motion to get that written in.
Because the motion maker should say, it is being denied for the following criteria.
Not elaborating until we get the seconds.
Right.
You know, saying it doesn't meet the spirit of the ordinance. It doesn't meet the hardship criteria. It is going to diminish property values. And then we get a second.
And the seconder would know what you're saying those criteria are and presumably would agree with that.
And then if the seconder or anybody else wants to add criteria that they think, then we would make a motion. Somehow we would get that into the final motion. There's lots of ways to finesse it, but somehow we would write it into the main motion. The formal way would be to say a motion to amend to add this criteria.
So,
Sometimes you can do like a.
so I think the cleanest way for Steph's purpose, under the scenario you're describing, where you say you're a seconder or a potential seconder, somebody's made a motion to deny on one variance grounds, and you're a potential seconder, but you think it fails on 3.
Yep.
Well, you wouldn't second it.
1 second.
You would let it fail, and then you would make a motion to say, no, I move to, on all 3. That would be the cleanest for Steph's purposes. I understand in practice that's going to be really hard because you're in the moment and you're, you know, oh, actually, you know what, as we talk about this, it actually fails on 3 as opposed to just 1. So in practice, it's gonna be a little challenging, but
You could, the seconder could suggest to the maker, or the potential seconder
Sure.
could suggest to the maker, you know, maybe it doesn't meet this criteria either, and the maker could modify.
I would second if also, yeah,
Exactly.
exactly.
Just to make it.
Tom? The other Tom?
Yeah, couple of comments. Some of this touches on maybe, I don't know what you had in mind when you were talking about board member etiquette. I don't know, are we in that section yet,
No,
or is
we're
this a
still on
different section?
motions.
Trying to decide whether I reserve comment. With regards to our process for making and amending motions, let's try to remember that, you know, time is valuable, and we don't want to create a process that's perfect from a theoretical Robert's Rules standpoint, but extends our meetings unnecessarily through repetitive motions. I amend this, I move to that, blah 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 blah. We're going late enough as it is, way too late, and it's one of my major gripes about the board is that we go too long every single time. So I am not in favor of making an overly complicated process. Nobody says we have to follow the strict Robert's Rules of Order.
We do need to be clear for Stephanie, that's the issue.
Yeah.
We do, but that's why I'm trying to decide whether my other comment is about board member etiquette. I think that we, as board members, and perhaps I fall victim to this, or I'm a perpetrator of it as much as anybody else, we expound too much at times on not matters of fact, but matters of opinion. Let's say for a denial. I can't support this motion, this application, blah, 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 for whatever reason. Maybe if this shed was moved over here, I could support it, or maybe if the dormer was not there, or if the door was a different color, or whatever the comment is. Those are matters of opinion. There are matters of opinion expressed by one board member. They unnecessarily extend the discussion, and they also set the applicant up for failure in a revised application because they respond to that, and I've seen this happen, thinking that it represents the opinion of the board when it doesn't. These are not expressions of fact. These are expressions of one person's opinion that gets acted upon at times and doesn't get supported in the end. So I really think that a little bit of introspection on our part about what is appropriate for us to discuss and what isn't will take away some of the fog from what you're trying to lead through to get to the pertinent facts, not matters of individual preference or opinion on hypotheticals that are not before us. And that possibly is part of what we need to address. And I don't know if that's etiquette or if that's, pertinent to this discussion, but I feel that it is a problem that we need to address, and we can address it completely on our own.
Okay, so any other thing on motions? Jeff?
Something I just wanted to bring up was attorneys presenting for the applicant often take the first 2 criteria together. But I realize that for staff, it's better if, as the motion makers, we separate the first 2 criteria. And I see why when you're writing the findings of fact, they are 2 different things. I'm guilty of putting them together too, just because I thought that's what attorneys do or something. So.
I mean, the law says you can
Law says
you can take the two together. So it's not inappropriate to take the 2 together, and then for Steph, she can merge the description. It's not inappropriate. In all cases, it's not perfect, but
It does become an issue if you take them together and then you elaborate on one more than the other.
Oh,
Yeah.
So that's the only time it gets confusing for me. Because I have these boxes, and if you took them together, I can just copy from the first box to the second box, and it's good. But if you say you're going to take them together, and then you speak to one, and then you speak to the other, it does get confusing.
Okay, Dave?
Yeah, and I know when I was chair, sometimes helping out the staff with sort of some of the fine nuances of of those forms and the information that was in the letters back to the applicant was a important part of that final review process. I'm good with what you're kind of proposing. I do share some of Tom's concerns and that we're just, adding yet another layer of complexity to our motion making. I guess my one precaution would be, I would ask the chair and the vice chair that I think that's gonna make it even more important that you recite back to the board just prior to the vote exactly what everybody is voting for. And I think that's something that we just need to be very, very diligent about doing so that we're all on the same page. Because after we go through all that discussion, sometimes people start to lose track of exactly what did we just go and what are we truly deciding when I vote yes or no, right? And then the last thing I would just add is and I don't think we do this maybe even enough for some of these really complicated or complex cases. The handbook for local officials does note, and maybe Trevor, you can add in if you feel positive or negative about it, but the board does not need to reach a decision on the same night as the hearing was held and can take time to consider the evidence and testimony to render a decision at a later time. I mean, we could, if we're really struggling with putting together a coherent motion, we can say, hey, you know what, we've taken enough time on this, and then go and you can even assign somebody or have somebody to volunteer to develop a motion that could be presented at a subsequent meeting that would then be taken up by the board to go and make a final decision on the application. Obviously, you don't want to do that with most of them, but there are some that I know that we're really like all struggling to be able to come up with the criteria that we're saying. So I don't know what you feel about that advice in the handbook.
Certainly, and I will use this to kind of segue into another point that I'd like to make, if that's okay with everybody. But the statute provides 90 days from the date of receipt of an application to make a decision. So as long as you're within still that window, or that window as may be extended by continuances and things of that nature, you're certainly well within your right to move it on to another night. Now, of course, mindful of what Tom's been discussing here, which is your time is valuable, and you give a lot of time to these things, but sometimes it's appropriate to go and get that, maybe let it sit for another meeting, or another thing that I know that we had discussed is asking for more information, either from the applicant or from another department, another city department, or from a third-party consultant. I mean, these are all options to you. They're things that other boards, at the planning board, that TAC do regularly as a matter of course. I know the Board of Adjustment doesn't regularly do it. I don't know that I ever remember you doing it, but it's certainly available to you to go and get that extra information, either with the consent of the applicant or not. I mean, if they won't let you get more information, you can deny without prejudice as well. That's certainly an option before you. You have a lot of resources available to you, and some of this stuff is really tricky. And I think back to, I was just at the planning board the other night, and Chair Chelman talked a lot about the uncontroverted expert opinion, right? Which is such a good point. He brought up there's some uncontroverted, and you can't go against an uncontroverted expert opinion without some other expert opinion. Whether that be something within your realm of expertise or by going and seeking expert opinion. And we have experts that work for the city that have some of these expert opinions, or you can go and get somebody to review it from a third party perspective.
Which planning staff and you guys would support. Like if we said, hey, we need another consultant to go and give us their impression of what this applicant is telling us in this great detail is thick.
Yep, and we do it. It's not just the planning board. It's not just TAC. The Conservation Commission, HDC. It's done frequently at other boards, and people get grumpy about it, but you have to make the right decision here. So.
That just reminded me of a question. Is like if you have different types of experts, for example, for the property values one, if you have an assessor versus a realtor, they're both experts in providing opinions, but if they're just different expertise, so that's still legitimate because it's not.
Well, we pick between them.
Yep, you can.
So if we have two expert opinions, we're the finder of fact. but if we have one uncontroverted expert opinion, we can ask for another one, or we can just accept that.
Yep.
So-
And the different levels of qualification, that goes to credibility, right? And that's something you guys get to weigh.
So, all right, so I think we're gonna move off motions. I think it's gonna take us a little bit of time to sort of figure out this new scheme. Hopefully we get some easy applications to sort of try it out on. And so I think, why don't we go, because we don't wanna be too much later, and we still have, I wanna give these folks more time to talk, but I think board member etiquette, I think was the last one that we had for
Yeah.
this.
We had kind of rolled it all into member responsibilities, which I'm gonna throw to Trevor.
Sure.
I think we covered a lot of it, but
Yeah, I mean, it goes to, you know, a point that you have all been kind of circling around and making. I mean, you know, Tom certainly and Dave, Tom and Tom, which is this. You know, a wise man once told me about a sliding scale of money and human interest, right? I wonder who that might be. You know, and when you're talking about, you know, the level of precision and the level of time that you're putting into a particular application, I don't think it's inappropriate to spend a lot more time working through things that are really at the high end of that scale, right? I mean, if there's some application that has some likelihood of being challenged or contested, I think it's more appropriate in those cases to have a high degree of precision in your motion making and really take your time with it and take your time working through the decision. Not to say that the smaller decisions aren't really important, and they are, but it's not inappropriate to really take your time and be precise with the motions and backing it all up. I mean, you want to do it all the time, you want to be in the repetition of it, but you know, it's within your judgment to say, you know, I'm going to spend a lot more time talking through this issue with everybody to make sure I get it right. When, you know, the application's this thick, when there's a lot of information before you, as opposed to, you know, an application that's maybe 1 or 2 pages, right? I mean, it's you know, and that's within your judgment and within the control and the judgment of the chair as well, to try and help move things along. You know, you're all professionals, you're all adults, you know, I'm not gonna sit here and talk to you about, you know, being nice to each other, you know, that's, or nice to the applicants, but, you know, as I think, you know, but on the other hand, you might be the only interaction that somebody has with their local government, right? On a given day, on a given year, or within their lifetime, you know, and it's important to kind of instill those values of, you know, something that, again, I was taught and I try to live, you know, to try and instill, you know, confidence in your local government, right? Anyway, that's kind of what I have. I feel weird kind of telling you guys this because, you know, I see you guys up there all the time and you're the ones that are living this, not me. So, but again, happy to answer any kind of questions, more specific questions any of you have.
if I could just add one thing, just going off of what Trevor said, I mean, you guys are all very good to each other. Not all boards are as respectful of each other as you guys are, and I think that's really great. And then, yeah, just everything we've been circling around, being respectful of each other's time, showing up prepared, showing up on time. I'm not calling you out. We threw you a curveball tonight. But for the most part, these are things that, you know, you guys do on a regular basis. So, and that makes my job easier too. So thank you.
And you know, you guys are often, as I say to others, you know, you are very often the last word on what the law means in Portsmouth. And, you know, I tell that to people all the time, and, you know, and I get to defend your decisions, and, you know, I feel very privileged to be able to do that. You know, again, I see the way you work through problems, you take it very seriously. Anyway.
Trevor, I would be, I have to admit that I don't have any idea which of our decisions are being challenged in court, what the arguments are, and whether or not, you know, motions I supported or even made are being overturned in court. How do we, I mean, is it just up to us to kind of figure out what's being brought before the court, or is there a way you could provide some kind of periodic feedback to us?
Yeah, of course. Certainly. you know, I guess I'm remiss that I didn't think of that myself. Certainly, I'd be happy to give the board just even written updates, and or come and talk to you and tell you what's going on appeal. I mean, I can tell you right now the two properties that are under appeal, 134 Pleasant Street with the denial of the drive-through variance, that is up on appeal, as well as all three decisions related to 58 Humphreys Court are all being appealed and cross-appealed by the property owners appealing, and as are the abutters there. So that one we're kind of fighting on all sides, but
I mean, I don't know if anybody else is interested, but I certainly would be interested. I think that would be a good learning feedback loop for me.
absolutely, yeah. Genuinely, I apologize. I should have thought of that, but I can certainly keep you all in the loop.
I've been doing this for 4.5 years. I never thought of it until tonight. So.
Well, in my experience, you're also very good once a court decision has been made of getting that information back to the board,
Yeah.
and then we can get a chance to review it and
Sure.
discuss it if necessary,
Certainly.
what we can learn from it.
So I think that was it for our agenda meeting, right?
That's pretty much everything that we had flagged. I did want to review one thing that Dave actually brought up, and that was Map Geo.
Oh, David with his map geo.
It's a very powerful tool.
I don't know if I could do my job if we didn't have this tool. It is, when somebody calls and they say, I want to put, a porch on my house, the first thing I say is, what's the address? You can see some really good detail of information. Let's get this out of here.
Isn't it the tax map?
So this is,
Also,
Yes.
it's not the official tax map, but, it's
It's Map Geo.
Yes, Matt Chivo.
It's a parcel map, yeah. If you go to themes, this is just the Google map. Our aerials are updated every April. You can zoom in and see some pretty good detail. You'll see that the parcel lines don't always match up, so I usually give the warning. They could be, a few feet off, but
That one looks way off.
yeah. And sometimes it's the angle of the photo too.
did you pick this neighborhood for a reason?
Should we scroll to the house? But you can turn on the zoning map. You can turn on all the maps. We have the height map, facades, highway noise, incentive overlay, as well as wetlands and
That's helpful.
yeah, the wetlands I find are very helpful, and you can change the transparency. You can go back. What did it look like? 10 years ago. I guess not 10 years ago. 5 years ago. Oh, no, 15 years ago. You can also, if you go to markup, you can measure. Again, it's not accurate down, to the inch, but you can get a pretty good idea of, how far is one property from another. You can also, click on certain parcels and
Ownership.
get, ownership, the history. I use the property data.
Okay, go across the street so you can go right where I live.
I use this a lot of times for calculating building coverage, and this is all tax related information. So the field card is even more in depth. You can truly get a lot of information from this one tool. Any other tips or tricks?
This is what website now?
This is Map Geo, so
Geo.
you can get to it from the website, from the city website. You can also just search, Fort Smith map. Oh, that's not the right keyword.
So this is the one, the city website, Casey. That's how I usually get to the map.
It's under the assessor, second tab.
Yeah, it's also the first thing that pops up if you Google
It
Portsmouth
says
Map Geo.
maps.
So
Okay.
Now, I'd be remiss if I didn't take the chance here to, this is not official. These are not surveyed. These are, the best efforts. These are the best efforts of city staff. And sometimes, I've seen it. I've gotten in arguments with attorneys over it before. Sometimes you'll see applications come forward that just rely on Map Geo. And that can be fine. We go back to the sliding scale. That can be fine sometimes, but other times when, a high degree of precision is necessary, MapGeo is not sufficient, right? And you need an actual true survey in order to, really make a good decision. So, that's,
But I also think it can help you get a good sense of a neighborhood. Like sometimes when somebody is saying, hey, my lot's bigger than everybody else, I'll go to MapGeo and I kind of like look around. I'm like, okay, yeah, I guess that makes sense or not. And sometimes they'll provide us that info, but it can give you your own independent sense of what's going on. You can get home ownerships, like when the butters bring up stuff or, send letters and whatnot, they don't tell you exactly where they're at. You can go figure out exactly where those folks are located or what their interests might be.
You
Like-
can also, zoom right to the street level, which I find very
People don't have their houses blurred out.
But like a lot of modern tools, like, people relying on AI and things of that nature, the tool's only as good as it is, it requires a level of critical thinking. You can't just rely on it implicitly. That's my caveat.
Yeah, I mean, I haven't used it. This is Dave's thing. He is just Mr. MapGeo. But I have noticed sometimes there was one application where the wetlands on the MapGeo were different than where it was on the survey. They had actually submitted a certified survey. So obviously that would be the one that we would use. So
Yeah, if a property does have a survey though, does it get implemented into this, or they're just considered totally?
Sometimes it does. It'll
It's
be,
not- you can't count on it.
if I find something, in the course of my dealings, whatever, if I find something that's inaccurate on MapGeo that I find is an error, I'll send that over to Jamie McCarty and say, hey, here's some more information. He likes information. He's again just exercising his best efforts. So I'll send that information over to him, and he'll again do his best to keep it up to date.
A survey is not public information if you don't want it to be, right? So it's not just because you have a survey, it doesn't become public information unless you file it as such.
Yeah, that's right. That's just a document that your contractor will have prepared. Sure.
But most of the time, a survey, you're going to probably put it on record if you have it, because it protects your legal rights to.
I get that,
information.
but that's why it may not be updated, because you could have one done and it won't go anywhere.
It's a tool. It's not the be all and end all, but it's another tool that can be helpful.
And actually, almost every city has this, so it's kind of cool. You can go to other cities and see what properties are. I don't know. I spent a lot of time on this too.
Yeah, there's a few different vendors across different communities, but
Yeah, this is like probably the most
common one.
Most common one, yeah.
I would concur.
So I don't know if I don't want to keep people too much longer. If there's any other discussions or Q&As, I think there were things that Dave and Tom had also brought up, but I just want to ask city staff, is there anything else that you would like to discuss with us, or you were looking for us to discuss with you, or Q&A, anything? So,
I think we've covered everything.
I would just say if you're concerned about like the amount of time, I was just looking at your rules and regs, and you just have public comment. Like the planning board has first, second, third round, and there's time limits for public speaking. If you're worried about endless hours of public comment.
we have the 15 minutes for the applicant, and then 5 minutes, and then I have cut people off, and then they've had to come back.
And that was actually one of my topics. So.
All right.
My only other plug that I'd like to just make is, it's always good to provide information to the board as a whole. If anybody has specific questions, I'm happy to, if you want to run it through the chair, I'm happy to, provide feedback or help you work through any burning questions you might have. I'm busy, but I really like this stuff, so I'm happy to help.
I've even availed myself of a coffee with Trevor. Just to sort of say, what? So, all right. So we don't want it to be too much longer, but I understand that Dave and Tom have some things that they.
And before we, just one more just a nitpick on the applications is if you can always just make sure if the applicant provides something that's supposed to be portrait, but it gets provided as landscape or vice versa usually. Unfortunately, I can't take my pad and do that because then it goes and just turns the image. itself again. So whatever we can do to just make, turn those, because unfortunately we don't have Adobe Pro. We only have Reader, and Reader says, no, you can't go and change the orientation on pages. So,
We do try.
yeah, thanks.
Alright, so Dave, why don't you start?
Thank you. So just a couple things that I suggested, and I didn't want them to take too long, but, and going for you as a board member and with your long history as an attorney, we had a case of, when I think it was maybe your first night that you were with the board, where you really were very concerned about the board denying and the applicant's ability to come back because of Fisher v. Dover. And I think we have, in my experience over, the 14-ish years of the board, we've always been fairly liberal with Fisher v. Dover when they come back. If we think that they've made, changes that really kind of are meeting the intent of some of the board's concerns, we don't want to belabor it with send the applicant back and have them come back before us. It's maybe something more that like you would see with the HDC or maybe a little bit more with the planning board. But you had some pretty grave concerns, and I just wanted to understand where you were coming from with the concerns that you think we could be putting applicants in jeopardy.
Situation was, it was close to a denial. And the discussion indicated that with some small changes, it might be approved. My concern was that if the board voted the denial, then because of Fisher versus Dover, the applicant would never be able to come back with the small changes. So I was suggesting give them a month. That was
You
all.
suggesting give them what?
Give them a month
To amend their application and come back before the board.
with the small changes.
Continuation or?
With direction. And I know we struggle with that all the time, right? So we like the finality of making a decision versus this more, HTC interaction of, change this window, do this type of shingle, and then come and see us in a month. I think a lot of times our board's kind of been resistant to that, where we'd rather just say, hey, presented and advertised, you're not meeting it, here's, as through the discussion, maybe you'll have a better sense of what the board would have accepted, but you're gonna have to come back and beat that Fisher v. Dover hurdle. And I think for the most part, most applicants have managed to beat the hurdle with us, but are we not taking that hurdle seriously enough?
Well, the problem is, the hurdle is that in order to come back to you, they have to have a substantial change.
Right.
And what I was talking about was with minor changes,
Right.
they might turn a denial into an approval.
Mhm.
So they would never be able to get over the Fisher standard if you denied them and all they had to do was make minor changes,
Minor
because it
changes.
takes a substantial change to come back.
Okay.
That's what I was trying to deal with.
Second was demolition ordinance and demolition committee. I don't want to get too specific with some that the board will be looking at directly, but I'm just trying to understand, where does staff currently think that the demolition ordinance is at and its enforcement? And the demolition committee hasn't met in a long time. And then my other last thing is that when we make a decision, either at the planning board or the zoning board, that seems to now negate somebody's ability to use this demolition ordinance.
So before we talk about that at all,
Yeah.
we should discuss the fact that this is coming back as an issue in front of the board at the next meeting.
So I can.
And if you're not comfortable talking
No,
about
no.
it,
Very
I'm just curious where we think we're at.
Very comfortable with it. So the purpose behind the demolition ordinance, the whole idea is that before a building gets demolished anywhere in the city, there should be some forum at which people have the chance to come out and express their views regarding the demolition of the building, whether or not they actually have any right to stop it. And that chance is covered if if an application says, the building's gonna be demolished, and it goes to the HDC, it goes to the ZBA, or it goes to the planning board. You've now had your chance to come out, the people, the citizens of the city of Portsmouth and elsewhere, have had a chance to come out and talk at a public hearing about, this building that you love or hate or whatever. And the demolition review committee was conceived some years ago as kind of the stopgap between, you know, the gap filler between, you know, for those buildings that are gonna be demolished but aren't subject to site plan review approval, don't need a variance and are outside the HDC. That's the total sum purpose of the demolition review committee.
Okay. I guess my one asterisk to that concept of its purpose is that the representation on that committee reflected some strengths that I think our board and maybe the planning board don't really have, which is, you know, the Portsmouth Advocates, it has people from the Historic District Commission. It just has someone that can look at it with an eye and an understanding that I don't think our board is very well equipped with. And then the opportunity was there, and what had happened in the past was that through the demolition committee process, there was some type of documentation requirements that came out that people said, yep, we'll go and we'll take these pictures, these pictures, these pictures. We'll preserve this aspect of it, maybe like this little L or something gets saved. There was some compromises that were made there that are based off of an understanding of the historic nature of these properties that I just don't think we are equipped with or want to spend the time working on. So that was my one concern with what you just said.
Very well taken. It's not how it's currently set up. That's my answer to that, I guess.
One final question would be is, from a legal standpoint, would this board have any standing to be able to make a stipulation that would say that the ability to appeal to the demolition committee would not be negated by an action that the board has taken?
That would be contrary to the terms of the ordinance.
Okay.
I have a related question to this then.
Well, let me just, all right, related to David's point
Yes.
right now, okay.
It's almost the exact same way that you started yours. Would we have any standing to deny an application for a variance based on our opinion that it had within it the possibility of demolishing a structure, even though, I don't know, I mean, is there something in this zoning ordinance that I overlooked that says the zoning board has to approve a variance to demolish a structure? I don't see that. Maybe I missed it because I'm just too stupid, but my understanding is that our jurisdiction is to make judgments about applications that pertain to exceptions to this zoning ordinance. And it's not clear to me that we have the legal standing to deny an application for factors that are not addressed in the zoning ordinance. So am I wrong about that, or do we have that standing?
Second. Well, no, I mean, towards that end, one of the things that we are approving is not demolition of a historic structure, right? That's not one of the things that we're approving and that's listed in the public notice.
Right.
Yet it's a concern, and I think a legitimate concern that people can bring forward.
Let me maybe pump the brakes a little bit on this discussion, because you're clearly talking about the pending application, and
No, this is not
That's not the only one, but
But it is a pending application.
it is a pending application.
It is.
Well,
I'm worried about providing a legal opinion that may impact your decision on a pending application
That's
in a
fine.
public setting.
Yep.
If you'd like to have this discussion in a non-public setting, I think that might be a more appropriate venue.
Okay.
Okay.
Understanding, so some of the other things that come before sometimes are things that we think are really.
You wanna do it now?
Non-public session.
Public session now.
I did not necessarily. I don't know how the chair feels about
Enter a non-public
that
session.
or entering a non-public after the end of our discussion here.
I would say probably not, given the time, and that not everybody knows what you guys are talking about. So I would say that
That's
we
fine.
could do that before the next meeting, so, but.
Okay, and I'm fine with that answer. So sometimes people bring us things that we think are things that get brought up at technical advisory committee or in front of planning board for a site plan review or a subdivision review. But at the same point in time, while I think I know what they do, I'm not always sure exactly what it is that they're able to take a look at. And so before I would be like, hey, that's going to get taken care of somewhere else, I just would want to make sure that we're on the same page. And maybe a discussion tonight isn't the appropriate way, but if we can just get maybe something written up by the planning staff or something that just sort of explains what those are, so that I think we're better equipped and maybe would have like a cheat sheet that we could take a look at and say, oh yeah, this is going before site plan review, this is something that's there. Or maybe give us an opportunity, because I do think we could say, hey, we approve this, but it would be subject to getting a site plan review if one was not necessarily required because of these other concerns with the property, if that's something we could do.
Yeah, I think, for my part on this, I think some of it is certainly, if you're talking about it is a complicated question. If you're talking about traffic circulation, I mean, of course, that's something that, we benefit from having, some real experts on in terms of, fire, police, and public works, right? And that will be certainly addressed at TAC. But it's also a belt and suspenders approach too, of like, if you're talking about impact that some variance is going to have on another property, if inherent in what you're granting would be, say, a giant light shining directly in someone's bedroom window, I mean, sure, that's something that TAC's supposed to take up, but if it's inherent in your variance, well, that's something you should be concerned with as well.
Don't disagree with that. I guess my concern is TAC brings a lot of expertise that we don't have. Again,
Yep.
Planning board has expertise that we don't. And so a lot of my thinking at any rate is, hey, I'm going to defer to the experts in that. And I know there's a lot of concerns that are being raised here, and I think they're probably valid concerns, but they're not ones that we're in a great position, both from what we're required to go and do, and then from the expertise we're bringing to the table to go and answer some of those types of concerns. But I guess especially because there is two different things. There's site plan review and there's also subdivision review, correct? So I would like to understand for each of those, okay, what's on the menu of things that TAC and Planning Board are looking at for each of those. I think would be just helpful to have that information.
Steph wants to add
We
something.
can definitely work on a cheat sheet. I think that's a great idea. In the meantime, you can look up the site plan review regulations as well as the subdivision regulations, and it does in the first section tell you what triggers site plan review and what staff are appointed.
Yeah, and I know, I mean, I rely on your staff report to tell me what additional reviews a particular application requires, and I think you guys get that, you go through this and you get that right. I'm just, when I see that there, what is that really telling me? And I'm not always 100% certain. And I guess I could study the ordinance more, but if you guys can give us a cheat sheet, that'd be even better.
Yeah.
And then lastly was really time limits for speakers. And I think we've been struggling with that over the past, several meetings. And I know, 15 minutes, and we've had a couple of applicants come before us and say, hey, I need more time. And I think we've been pretty good about that. But back to Trevor's fundamental point of, in many ways, we're often the only, one of the few, or maybe perhaps even the only interaction a lot of our citizens have with city government. I do want to make sure that they're always feeling heard and respected. And towards that end, I just, a couple of things that come up is sometimes we have we have the applicant that gets 15 minutes, but then we have the counter lawyer, and keeping a lawyer to 5 minutes of conversation is just impossible. Sorry. I'm just going to tell you that's never
And
happened.
others as well.
The occasional engineer as well. But, how can is there some way that we can better, and we may not have an answer tonight, but I just think it's something we should be thinking about and seeing if we think our rules and regulations need more clarity, or just simply how you guys want to prosecute that. Maybe if the two of you want to get together to figure it out. And then just, I always thought that, first-time speakers definitely want to limit to 5 minutes, just out of courtesy to other first-time speakers, right? You don't want somebody rambling on for 25 minutes, and then somebody really just wanted to be there for 5 minutes, like, man, I was going to go home, but I didn't get my chance for my 5 minutes. But then second-time speakers, is there some way to better reflect, okay, you've got some things to say, please be concise, but, what's on your mind? And I'm not sure how we want to deal with that, but it's just something that I think we've struggled with.
And I think what you're talking about is the Chase Home application, not to get but that was a special, where you guys, I could not chair that, I had to be recused, but where you set out specific ways of actually presenting the application, so.
there's been a few others as well. Some of the, you know, some neighbors hire an attorney and they've put together a pretty elaborate thing that's probably about the same thickness as what the applicant's attorney put together, saying why the applicant's attorney is you know, off their rocker. And then, you know, they get the counter one that, oh no, that attorney's off their rocker and whatnot. But, you know, just trying to make sure that we can give equal balance to somebody who's going through that extra effort. You know, and it all goes back to, you know, Mr. Rossi's point as well of, hey, we don't have forever on these things. Conciseness is really important. But at the same point in time, we recognize that there's a lot of counter information. We're giving this person 15 minutes. How do we be fair then to the other people who are saying, man, they just talked on and on and on, and you're making me sit down after 5 minutes, from a perceptual standpoint.
And likewise, do we need to clarify or have additional instruction up front? I think it's almost every meeting somebody's come with additional information as a speaker.
Yeah.
And it's like impossible to process. And
Yeah, Steph and I had a conversation about that too. We may be having an upcoming rule change on that, just because that was a particular problem with one of our big applications.
It just sets, or I don't want to say we set a false expectation, but there's almost this false expectation that I can enter more information
Yeah.
into the record.
I mean, I think that it's a sort of balance because it is a public hearing. And so you are supposed to be, you know, receiving information, but at the same time, if somebody's handing you not just a picture, but like a written thing, I mean, I think we have to be honest, my ability to digest this is going to be pretty limited.
Like an exhibit, to your point, an exhibit to accentuate or support their point is different than a 50-page report.
So,
Or if you're having that, then that needs to be.
And then the applicant's attorneys also say like, hey, what's this thing that, A, I don't have time to look at it, and B, I didn't even get a copy of it.
And there's no
yeah,
discovery.
and that's it's problematic, and we've been talking about it. But we do have to keep in mind it's a public hearing. So, but at the same time, not try and cut down on the amount of stuff we're getting on the fly.
So, in a previous life, all I did was run public meetings. And we eventually put in a real hard deadline on written documents. So it was several days in front.
Yeah, I was about to say the applicant has a deadline. Why wouldn't anyone else? I mean, they should see
Anybody
that.
could walk to the mic and say whatever they wanted, but we were pretty clear that, you know, I would not distribute to the board members any written documents received after a certain time period. And I was brutal about it. I mean, I got calls from people 5 minutes late, and I said, nope, sorry, I missed it.
I mean, it's all a balancing act, right? I mean, going back again to Trevor's point of, we're really here to take in information from everybody and synthesize all that information. And maybe under certain circumstances, we're really seeing like a lot of this last minute conversation that we do postpone our decision making, give us time to really digest all of that. But it's probably not a one size fits all answer, but just something I think we need to be conscious of and kind of like working on and trying to figure out a way of doing that.
And the other piece, of course, is that the public doesn't see the application until we post it on our webpage. So you almost have to have their deadline be after the applicant's deadline.
Yeah, or like, that was a great point. I mean, it could just trigger, if there's additional information, then it triggers a continuance versus an immediate decision, so.
So, Dave, you done?
That is all I had. Thank you, Madam Chair.
Okay, so Tom, you had some things that you wanted to raise, and I would like us to try and get out of here by 8 if possible.
Okay,
so.
I think mine are pretty quick. The first one is, I'm a little confused on how and when we decide to schedule a sidewalk. I'm a little uncomfortable with waiting till the public meeting to ask for a sidewalk and then have a vote, because then we're pushing the application back a month. And I would be more comfortable if we were clear that, you know, if any of the board members would like a sidewalk, we ask the chair, and you make a decision whether you think one's necessary or not. If we don't like it, we can always bring it up in a meeting, but that way the board chair, the vice chair, you know, has some control. The staff's not getting bombarded by individual board members asking for a sidewalk or objecting to a sidewalk. You know, you go to the staff and say, we need a sidewalk or we don't need a sidewalk. We could do it in advance, because it's unclear to me how we get one. And I think there've been, you know, 1 or 2 times over the last couple of years I've been on the board where a sidewalk might have been helpful.
Mm-hmm. I think it should be done before we actually hear the application too.
Yes. Yeah.
I think the best thing to do is run it through Steph, like, if anyone really thinks that they need a site walk, I run it through Steph and then Steph can bring it to me. I think that'd probably be the easiest way to do it.
Still,
But,
it's tough though, because we only see the applications like a few days in advance of the
yeah, and I
meeting,
think it
right?
has to be posted because we'll have a quorum, it has to be posted in 2 public places. So that, the timing may be difficult.
Just need
So,
24 hours notice, but
20, okay.
8 minutes.
But with Map Geo now, we don't need
Yeah.
sidewalks.
Well, once the legal notice is passed.
I would just add, without getting into specifics, it has come up where if someone was interested in a site walk, it went to staff, but then the next steps of how to see if everybody wants a site walk, or if we do have a vice chair or chair make the decision, or how the steps go, because it's, at best you get a week before, after the agenda, after the application is out, or the packet, but before the meeting. If it kind of just doesn't happen just because there was no steps, but if there was a procedure, I guess.
I think it could be at the discretion of the chair,
Okay,
just to
yeah.
keep it simple, not to aggregate power to myself, but for us to make that decision in the group, legally is impossible.
You're the cat herder. We're fine with your role as the cat herder.
It doesn't come up often because most sites you can just see from the street, but
But it is helpful, and there are very strict rules to how we conduct site walks too. We did it for the Heinemann Building project, just because I chaired that and I just felt like we were really struggling with it, and it just helped to sort of put, this is where building A was, this is where building B is, and it just, but.
2 more things, hopefully quick. I get the impression that the agenda order is based on when the proposals arrive. Is that correct?
Yeah.
You guys have probably wrestled with this longer than I have, but I always feel sorry for the special exception request that goes on at 10:30. Is there any, have we thought of any way to like?
You could take them out of order. You
Yeah,
could always vote to take them out of order.
It's always a fairness thing, though. I mean, they did get their application in. It's a very easy and fair way to say this is the order that we're going to follow. If we start playing favorites, and then their thing ends up being complicated,
Yeah.
now you're pushing maybe a whole lot of people who want to talk about something to be there even later, right? So it's very tough. I agree with you, though. I mean, but at the same point in time, you know what? You have to come before the board. You got to expect that this is all part of the process. You may be
Being bored silly in the audience.
I mean, you can.
We often tell people that the sooner you get your application in, the higher on the agenda you'll be. So don't wait till the deadline, get it in.
Seeing as we are, as Trevor pointed out, the only representative of our local municipal government that they're likely to encounter, we should be taking, I was going to say this in a different way, but we should be taking into consideration the efficiency that we project, and if it's obvious that there are things that can be quickly cleared up, I would be in favor of what David is suggesting, that they just be put, a simple application, hasn't received public comment, whatever, just arrange the agenda appropriately so that we could project economy of effort.
But we can't.
To be fair, sometimes lots of public comment comes in right before
Yeah.
the meeting. And sometimes there are times where it's hard to tell. I think the easiest thing to do would be to take them out of order at the meeting.
Okay, so it's within our ability to do it, we just have to do it.
Yeah.
Okay, fair enough.
So,
Okay. I'll go along with that. The last thing is just a question. The city council revised the ethic ordinances in early 2025. And, I thought when I got reappointed that I'd have to complete the training for the ethics ordinance. I've never been contacted on it. Nothing's
Yeah.
ever happened. I don't know about the new appointees, whether you guys completed the ethics ordinance or ethics training or not. I just am curious where we're at on that, where the city is at on that, to be honest.
So my the way it's been explained to me is that it's being rolled out to new members, new volunteer members, as they are inducted onto boards. I'm not sure how that process has been playing out in practice. It's something that in response to your question, I'll be frank, in response to your question, I have brought to the attention of the deputy city manager, and hopefully we can implement an efficient process to roll that out.
So Kevin would have been the one that got, Mike, sorry, Mike. Mike would have been the one that got the ethics training. Did you get the ethics?
And Bob?
I did not get it.
So I don't think that has.
You probably wrote the training manual though.
Well, I guess I'm a little concerned because,
Yeah.
I went to one of the governance committee meetings last summer and the city manager said we would all be briefed on it, or it would at least be introduced to us. And, nothing's happened that I can see.
I understand.
And it seems like,
Again, in direct response to your, the best I can, I apologize. The best I can give you is in direct response to your question. I brought it up, and hopefully a new process will emerge.
Because I also think since the ethics ordinance has changed, like, I don't actually even think I ever got ethics training, that we should be all trained on the new ethics ordinance, not just the new members.
Yeah, I agree.
I agree. Just talk to you first.
Is that ethical?
I think so.
Is there anything else?
No, I think I'm done.
Okay, does anybody else have anything? Okay, everybody's looking sufficiently exhausted. So I will ask for a motion to adjourn.
Move to amend?
We're adjourned.